coats than even umbrellas. But if you have your umbrella, please bring it out. It's important because we're in the rainy season, as you can tell. But welcome to Inside Pages on Metro Television. We have a lot to talk about this morning. And the first is that there's a big event happening on Monday. It's a demonstration, it's a protest. Some political parties have come together to protest against what they believe is an attack on Ghana's judiciary. And this is about the suspension of the CJ and all the issues that have come up as far as this matter is concerned. The minority has issued a statement in support of this demonstration, and quite a number of other issues have happened. So that's one of the issues that we intend to look at. But we want to find out from, as far as that is concerned, whether this is a waste of everybody's time or we need this kind of demonstration to sort of, get the decision to reverse if it's even possible in the first place. So that's one of the issues we intend to look at. The second issue we intend to look at on the show this morning has to do with the New Patriotic Party's thank you tour. Now, the thank you tour is ongoing, but it is turning out to be a bit unproductive or counterproductive, as some would say. And some of us actually said it should be an apology tour, and so on and so forth. And now we have a situation where the former member of parliament for that same central, Kennedy Japan, has actually withdrawn from it. The national chairman of the party has also said he's taking a bit of a break. Some are reading all kinds of meanings into that. But there's quite a number of things to look at as well as far as that matter is concerned. So stay with us here on Inside Pages. And when I come back, I'll let you in on my guest for the show.
Mommy.
Michelle say, fe.
Different era, better result. Time has changed and time has brought Kel Choco Toothpaste. Healthy gums, anti-cavity, fresher breath, and it whitens teeth. Kel Choco Toothpaste. Sankofa.
Yenchi. Kel Choco Toothpaste.
Happy smile.
This advert is FDA approved.
The Ghana Celebrity Impact Awards, GCIA, is an annual award ceremony that recognizes and celebrates the outstanding contribution and impacts of Ghanaian individuals, corporate entities, and celebrities. It celebrates Ghanaian philanthropy, promotes social responsibility, empower youth and community development, and celebrate achievements in giving back to society, thereby fostering national pride and unity. Here are the nominees for the Impactful Celebrity of the Year 2024 Female Category: Nana Mama Brown, Jackie Apia, Nadia Buari, Denta, Yvonne Nelson, Martha Ankoma, Juliet Ibrahim, Bella Mundi, Hamamat Muntia, Dinah Hamilton, Ohineyiri Gifty Auntie. To vote for the Impactful Celebrity of the Year 2024 Female Category, go to www.GhanaCelebrityImpactAwards.com. For enquiries and table reservations, call 053-755-0058 or 053-753-5390. The Ghana Celebrity Impact Awards is brought to you by Visa King, GCIA, celebrating the spirit of giving back.
Yes, next. Hey, Nadia Benson, Asamo.
Me didn't tum. Mr. Friendly Calico, just call me cockroach. Now, Mr. Friendly once now.
Hey, that's a new. Improve car. Yeah. Captain was key to double the action.
Me did this sasso spray. Mr. Friendly sasso quell.
Yeah, go my Tonton Preko.
Said a vote in the by and I in a share the entire Nipa Bibre, Ankotum, and in I share Professor Okwe National Elections Review Committee. No, Omoye Jumano, General Secretary, a boss, were called into the details, summary, the entire Nipa arm vote, the entire Ushening in Nipa Bufuye, a sema. Ye inform so ho ye juma mom but ye inform so bebre so ho ema nipa ebufuye omo se omo nkoto abano men kani nyina biom because general secretary akani nyina but me so me pese me gina my naimo party naimo gaban so naimo me say ampa ye inform so mom fan cheyen ye inform so Nyame ya adom ena ya samba kwan a ye fa so a mfomso no bae ye besfa kwan foforo na ya siesie niema bibiri ama mo nyina de ntia medwin se Nyame adom ye beba in 2028 no uhwe Ghana abakosema saa na etie o Ghana ye history uhwe ubeba aban mu after 8 years na ye pese o free ho mokai President Kufuor after 8 years ejuma fair oye ma Ghana free maternal care capitation grant health insurance ningina metromas ningina oye ejuma obe free aban mu na sebi nipa na omumpena ase menya sa but ene he's the most popular ex-president living in Ghana today. And yes, sir. I have hope, sir, with time, people will appreciate the work that we have done. So posterity will be kind to the MPP and to Nana Adodankwa Akufo-Addo. Posterity will be kind to the MPP.
In his welcome remark, Abronya took a hardline stance on the party loyalty and discipline, subtly criticizing members he accused of contributing to the NPP's electoral struggle through divisive public commentary. He described some members of the party as arrogant. Abronya also rejected a proposal by Kennedy Japan to reintegrate suspended or estranged party members as part of a broader reconciliation efforts.
Arrogance. And the dear Durabia Yadri. Raging ha, no, some 2 me 9 quite single constituency. I could catch you, be said. Yantuaba, my candidate, be more. More Menamotina Damukra, the Monsami flow, be said to Abba, my particular candidate. But the Binum Dimidi call ye campaign, Riano. Omuria, no, my concline. Abronya no, Najibo, me a campaign. But no crane is on more Bama campaign, almost a Bronya Nesumamo. Almost a Bronya Nesuma say, ye may a campaign co a Mebwa. A yes, some would do one dance here, some are near my no and flow beer. Some crofone saw me, yes, I do me deem by yero. A china on Bebamo. But this time, no, or my mammy buafu. Now, mom, more being could do a beatum. Who could do a beatum, ye? Not so, yeah, what's a young quiet a unity? I mean, it's unity, no.
In response, however, Kennedy Japan strongly defended his position on the reconciliation, insisting that inclusiveness, not exclusion, will strengthen the party ahead of future elections. He concluded that even poor people want to speak their mind in the party, delivering a tense and awkward moment at the meeting.
But party any baby to make a satisfied member. A back contributions here in Zika, and they talk as if the whole world is for them. It's not for them. And yet, a Kuruya, like some of them cannot even speak the way they speak. Because Bam Fia Kura Ufadi. If you were talking more, and Barum be too long. You see, your Panokura, Momianka, I will not respect you. But may respond to anybody. And yes, I can't show down. Minister will start means Resica. More here for promotion to be Kasako Kudroso. Yes, please. Who born dog?
Dr. Baumia in his address assured that the mistakes which caused the NPP in the 2024 election will be corrected.
Myself, any party, any government,
He is confident that the party will win the 2028 elections by giving the NDC what he described as a showdown. Kennedy Japan and Abronye were subsequently seen exchanging pleasantries.
It is obvious that the bold attempt by Mr. President to nominate out of the blue 7 judges to the Supreme Court is the first major attempt at all that they have rehearsed, a third-term agenda. All that the NDC is doing, all that our president is doing through the advice of the hawks of NDC is to set a third-term agenda for his leadership. They think that by packing the judiciary, there will be a smooth road for that third-term agenda. Were we not in this country, where even 2 Supreme Court nominees, after going through vetting, and were supposed to take their approval at the plenary, the same NDC said, by adding 2 more judges to the Supreme Court bench, Nanadu was packing the courts. Was it not the same NDC where that criticized the proposal to even nominate for appointment 5 more judges to the Supreme Court, and as a result, no further step was taken by the Judicial Council? What has changed? We leave it to the good conscience of they themselves. I, on behalf of the Minority Caucus, hereby say that what we're witnessing today under John Mahama's assault on the independence of the judiciary, an institution that we all know is the last line of defense for the rule of law, the protection of rights, and the survival of our democratic republic. Today, what we see is intimidation, political interference, unacceptable. It is repugnant. But I have something to tell our respected judges. Some of them, I am aware, we are aware, that are being promised by the NDC government. Today, it is Tokonu. Tomorrow, it may be them. They should listen and listen well. I want all judges in the country to know that their institution is under attack. The NDC government is approaching you, the judges, telling you that, oh, Tokonu does not have a good interpersonal relationship. She is snobbish, she is this, she is that. But I want you to know that if they allow them to use you today, tomorrow they will come after you. Yep. Act collective. Yes. It is your institution which is under attack.
Well, so as I did indicate, the New Patriotic Party, with support from 3 other political parties, are pledging to hit the streets on Monday, May 5, 2025, to register their displeasure over the suspension of Justice Gertrude Araba Esaba Saki Tokono, Chief Justice. Now, there was a press conference which was addressed at the party's headquarters at Asalam Down Accra, where the leadership of the MPP said that the protest march, which it describes as expected to be peaceful, is aimed at safeguarding the country's democracy and the rule of law. The party said the demonstration would start at 5 a.m. at the Supreme Court and end at the Jubilee House, where a joint petition by the political parties will be presented to President John Mahama to climax the protest. The press conference, which was held ahead of the anticipated May 5 demonstration by the political parties, drew support from many sympathizers, former members of parliament of the party, as well as current members of parliament. And so the NPP is saying that the NDC government had intensified its relentless crusade against the independence of Ghana's judiciary. Is that the case? Joining us this morning for a very interesting conversation on this vexed issue is Professor John Osai-Kwapong. He is the project lead or project director of the Democracy Project. Good morning, Prof. Thank you so very much for joining us. Yeah, it's just that I have some bad news for you. Prof will be leaving us at 9 because he has other engagement elsewhere. And so, but 1 hour with Prof for us is more than enough because he knows his stuff, absolutely. Let me also say that John Ndebugri Awini is also a private legal practitioner, but is an NDC member. John, good morning. Thank you very much for joining us. It's always a pleasure having you on the show. You haven't been here in a while, so we're not on good terms with you at all, but we can patch things up. It's okay. We're friends now. We're friends now. And also, lawyer Apia Dankwa. You know, I always struggle with the first name.
No, so it's a compound name, Apia Dankwa. The first name is Andrew.
Sorry?
The first name is Andrew.
Andrew, yes. Lawyer. All I'm saying is Andrew Apia Dankwa is a private legal practitioner and also the spokesperson for Alan Chairman's movement for change. And good morning, my brother. It's good to see you.
Yeah, same here.
Yes, and he was here last week. He's here. You know, he's a bona fide member of the show, unless he has other things to do elsewhere. Let me also say that Kwame Uredu is here, a very good friend of mine as well. He's a private legal practitioner as well, but also a member of the NPP. So, Kwame, good morning. It's good to see you on the show.
Yeah, good morning, my brother. I'm happy to be back.
Yeah. The other day you came, you're in your fans.
Oh, that's nice. I mean, we do our best. You're also the best.
Yeah. They say you're controversial small, but it's okay.
It's okay. I mean, a man should be known for something at least, you know. Yeah.
Anyway, so let me start with you, Prof. I mean, you will be leaving us at some point, so let's have this one-on-one with Prof briefly before I bring the rest of you in. Now, Prof, you are a champion of democracy. Or, in fact, almost all your life, all you've done is to see countries' democracy develop and get better and get better and get better and so on and so forth. There's a demonstration on Monday, and we've all heard the reasons why this demonstration is happening. The MPP suspects that, or they believe that Ghana's judiciary and Ghana's democracy is under attack because they believe that the NDC government deliberately is scheming to oust the CJ. This has nothing to do with law, but everything to do with politics. And so they want to draw the attention of Ghanaians and attention of the world as to what is happening in this country. And they have they've roped in some other political parties. I just don't know the names of those political parties yet, but obviously not the major ones that we know. What do you make of this democratic exercise? How important it is? And do you think that this kind of tilts the scales in any way as far as the ongoing process, the Article 146 is concerned?
Okay, good morning once again. Thank you very much. Of course, it's their, it's their constitutional right to demonstrate on any matter as citizens of Ghana. As I've said a few times and written a few times, the issue with 146, especially 6, as it relates to the potential removal of the Chief Justices, we would have to go back and fix for me some of what I call either the weaknesses in that article. I mean, at this point, you really cannot fault the president in terms of the process that he's following, right? He's following the process as exactly laid out in 1466. Now, the nature of partisan politics is such that different people may read different motives, either based on prior statements made or not made. But overall, you cannot say that the steps that the president has been going through are unconstitutional steps.
Okay.
He's definitely following exactly how the Constitution is designed to make this process play out. Now, as to whether you think 146 should have been triggered or not is a different story. For me, my worry is our partisan politics is such that once a precedent is set, it is followed, right? It's this sort of notion of a precedent set means a precedent that must be followed. I have argued that if you are going to invoke 1466 and apply the highest form of sanction to your Chief Justice, which is removal from office, it has to be something very egregious. Except, again, the Constitution doesn't also give us clarity on what, quote unquote, that something egregious is. Stated misbehavior and incompetence can be very relative unless in the face of, let's say, if we discovered the Chief Justice on TV, on a video having taken $1 million bribe, right? That one, reasonable minds would not disagree on that to say, no, this is really stated misbehavior. But there are other things that are subject to interpretation, differences of opinion as to what exactly constitutes stated misbehavior and incompetence. And it is some of that lack of clarity that lends this process to hopefully the checks that are built into it, you hope that would raise the bar to say, look, this really has to meet a certain threshold. So you would hope that the advice of the Council of State, you would hope that the 5-member committee would dispassionately look at whatever evidence these petitioners have presented to make sure it really meets that bar, because again, you are talking about the highest sanction you can place on the highest officer, of the judiciary, which is removal from office. So that's one. Two, I also don't want this to become, you see, you don't want the removal process to be a tool for settling differences over maybe how a court ruled or certain decisions that a Chief Justice made that you may disagree with, right? You want to also make sure that when this process is done, that doesn't become one of the consequences. Because again, we know the way our politics these days play out. And you can be rest assured that if this doesn't meet that high bar of stated misbehavior and incompetence, that give it another 1 or 2 turnover elections, you would see this process triggered again because you've set the precedent for that to happen. The demonstration, I guess, is going to draw attention to, the issue. I don't know if it's to bring some pressure to bear on the president, or whether it's the committee to sort of rethink, the process and things like that. But we are dealing with what is. This is the process as laid out. We may not like the process. We may think that it has certain flaws. I believe that it has certain trappings that may not bode up well for the country's democracy. But it is what it is. We have a constitution review process going on. I have submitted a memo to the committee asking for some particular things to be done with regards to this particular article, so you can safeguard the judiciary as a safeguard of one of the safeguards of Ghana's democracy. So those are some of
those are preliminary comments. I'm going to go around the table and get everybody to give their preliminary comments on that. But there's one issue which I want to run by you, which is, yes, indeed, it is the case that they're based on decided cases, based on case law. This is supposed to, and of course, based on the 1992 Constitution, this is supposed to be an exercise in camera. There are some who are raising, if a political science scientist and democracy and Democrats and democracy, what do you call them, champions like you have said, or advocates like you have said, have expressed a certain opinion that this in-camera thing doesn't help at all as far as the transparency and the trust in the system is concerned. So we perhaps need to go back and take a second look at it. For instance, what is it that the petitioners are raising? Okay, what issues do they have with the Chief Justice? That should be made public. Okay, instead of concealing it from all of us. Where do you stand on this? Do you think the current, of course, the thinking behind it, so the philosophy behind it is that you don't want to sort of pre-embarrass the person against whom the petition has been filed, just in case there aren't even any substance to what has been raised. You know how perception in this country can be very rife, even if the grounds are fertile or the grounds are not that strong. Yes, there may be some, they may have a case there, but where do you stand on this as far as this matter is concerned, which is keep everything secret, don't bring it out?
I strongly disagree with that position, and I have actually, one of the recommendations I made to the Constitutional Review Commission in my memo to them was give the process a lot more transparency, right? Okay. I mean, as a citizen, if you are going to trigger this article of the Constitution and again impose the highest sanction penalty for misbehavior on the Chief Justice, I think it will be good for transparency and accountability purposes to let citizens know exactly the basis for doing that. So yes, you may not give citizens the full petition, right? But at least I would want to know as a citizen, what is the case against the Chief Justice, right? Even if it's a high-level summary where whoever is president has received a petition, is sending it or is asking the Council of State for advice, would say, okay, I got this petition from one person, 2, 3 persons. The key issues against the Chief Justice are these 5 things. Upon advice of the Council of State, we are forwarding, something like that. Otherwise, what you end up with is, when there is a vacuum, people fill that vacuum with their own information.
Yeah, but Prof, we live also in a country, we live in this part of town where allegations, no matter how scurrilous, no matter how frivolous, no matter how empty they are, once it's a mere claim against you, it gets stuck, doesn't it? Correct. People see you and they perceive you as such.
But if you weigh the two together, right, the defects of lack of transparency and the challenges that may come with making the process a little more transparent, right? Which one would you err on in terms of the overall democracy architecture and what strengthens it? For me, would fall on a process that is more transparent, that gives citizens more information than one that holds everything private. I mean, imagine none of these petitions leaked. Imagine the CJ's response to the petitions never leaked, right? And you are able to hold everything so tight and so secret. And then you wake up one day and the sanction has been applied and the CJ has been removed from office. I mean, as a citizen, how comfortable would you feel unless you really trust not just the system and the process and the actors involved in the process? You would keep wondering, what was it really that occasioned this move? That for me, and the other thing, real quick, when you also live in an environment where there's very low trust in your key institutions, a secret process is the last thing that helps deal with that. So you look at Afrobarometer, trust in the courts, trust in parliament, trust in the EC. All our key institutions that make democracy work are suffering a crisis of confidence, very trust. So when people don't trust the process, the system, the institutions, a lack of transparency even goes to hurt the institutions more, right? So you're correct. I mean, once an allegation is thrown, a mistake, people may believe it no matter the evidence that ultimately For me, the transparency helps because of the environment in which we live. And like I keep saying, if you're going to remove your Chief Justice, I, as a citizen personally, would want to know what the Chief Justice did that is so egregious that no other sanction was appropriate but the sanction of removal from office.
Let me come to you, John Ndebugri, and I would urge all of you to do a bit. Let's be snappy on this so that I can come back to Prof for Prof to give his concluding remarks, so he can take leave of us, and then we can continue with our conversation. But John, there's been calls for a constitutional instrument to be enacted to sort of answer or to address some of these concerns that Prof has just raised, which is we ought to have some specifics in terms of what actually even constitutes stated misbehavior, matters about what should be made public, made known to the public, and so on. In fact, that's one of the things that some members of the GBA who met at Labadi Beach at that mid-year conference, I know you would have a bite on that. Out of 5,000 lawyers, 200 converged at Labadi Beach. Close to 150 left because it was about to rain, and then 50-something stayed, and 45 or 47 of them decided to vote and to pass a resolution that says that the suspension of the CJ should be reversed. Do you think that a CI is what will address some of the concerns that a GBA and Prof have raised about this whole process, which is Article 146, especially when it comes to removal of the CJ?
Most grateful. Thank you so much for the opportunity. Yes, the present law, as it is, will make provisions for the constitutional instrument, which you call the CI.
Okay. Right.
The executive power of Ghana, pursuant to Article 58 of the Constitution, is vested in the President. And that executive power, in terms of, if you read clause 2 of the article, it tells you that it shall be extended to the execution and maintenance of the Constitution. Now, the judiciary is provided in Article 11 of the Constitution, and if you read Article 11, which starts from 125 downwards, it provides for the procedure for appointment of Chief Justice and Superior Court Justices, and also proposes how they can be removed. In this instance,
please bring the microphone a bit closer to you so that we can hear you. Yes.
In this instance,
146.
Yes, 146. Yes.
Of judges and superior.
So that is the removal.
Yes. Okay. No, I think you're talking about appointment.
I'm saying that chapter 11.
Chapter 11
of the Constitution.
Okay.
Deals the entire judiciary.
Right.
And I'm saying that if you read Article 125 downwards, all the way, it provides for the appointment and removal.
Okay.
Of, in fact, everything about the judiciary.
Okay.
And I'm saying in this one, I'm being specific on the matter at stake now.
The CJ.
Which falls within Article 146 all the way, 146 clause 1 all the way to 11, thereabout. Right. Now, the procedure has been clearly stated in the Constitution, which is the supreme law of the land. So the call for a constitutional instrument in this instance case with me, to me, I perpetually disagree with those who advocate for the CI, because the Constitution...
So you're saying the 146 as it stands suffices?
Yes.
It's very clear. It's as clear as day and night.
On it.
Okay.
And if any other, the purported CI, even if enacted at all, will be subservient to the Constitution.
Right.
The Constitution is the supreme law of the land. So if the Constitution has provided for a procedure, why now call for a subsidiary legislation? Would that CI now come to override the Constitution, the supreme law of the land?
It's an interesting point.
So to me, that call is not sound, if I may put it that way.
Okay.
Because, as I was saying, the President is following the procedure as laid down in the Constitution. Now, if you read 146 clause 1 to 5, it sets out the procedure by which a superior court judge, other than the CJ, may be removed. That's where there's a need for a determinate prima facie case by the Chief Justice. That's if it is a remover, it is to remove any other judge of a superior court. The superior court comprises High Court, Court of Appeal, Regional Tribunals, Supreme Court. Now, in this instance case, the petition is directed at the removal of the Chief Justice himself. read 146. If you will permit me, if time will permit me to read 146.
Please go ahead.
You realize that there is no even need for the Tenero prima facie case when the petition is about the CJ.
Really?
Yes. Because 1466, if I may read.
Okay.
In fact, the termination of prima facie case is when the petition is for the removal of any other superior court judge, but not the CJ.
Okay. That's
if you
interesting.
read the entire 146 down to clause 1 to 11,
okay,
it's only when it is for removal of any other justice of the superior court that there's even the need for prima facie determination.
Okay, what does it say about the CJ itself? Or
CJ,
itself?
now 1466,
Okay.
see, that's where it starts from. That where the petition, that I'm reading Article 146, Clause 6, or Clause 6 of Article 146, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers.
So there's nothing there that talks about establishment
determination
of a prima facie case.
Now the 7 continues to say the committee appointed under Clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office.
Okay, so hold on a second. Why then did Derry, in that case, suggest, in fact, decided that the CJ ought to be, the CJ ought to make some comments or some input before a prima facie case is established?
But to be honest with you, like I said, this is the constitution I'm reading. No provision of such is provided there.
Sorry, the Frank Ejechum versus the Attorney General.
Yes,
Sorry, thanks for that.
That is interpretation of the
It was
Superior
Derry
Court.
who talked about the in-camera.
Yes,
Okay.
yes, it's interpretation by the Superior Court. But you and me know, my learned friend, that where a Superior Court decision conflicts with even an act of Parliament or a statute, obeisance is due to statute.
Is declared null and void?
I mean, I just wanted to bring...
Sure.
Yeah, sure. Sorry, I just want to bring Council into the fact that the issue of prima facie was not explicitly provided in the Constitution, but it was an issue of interpretation in the case of Ejechum.
Okay.
So now it has become part of the processes that there should be, if for a Superior Court judge, there should be a prima facie case, then by extension, the Chief Justice should be offered that process. It is the reason why the petition, when the President got it, he forwarded it to the Council of State to determine the prima facie case. That is why there is a suit in court that even in coming to the determination of that prima facie, which is a threshold sort of assessment, the respondent, who is in this case the Chief Justice, ought to be given a hearing in the form of responses. That the President has done that already. So people are saying that the President has even sort of dealt with the issue at the Supreme Court. So as for the matter of the prima facie, it is both applicable to Superior Court judges as well as the Chief Justice.
So, but the point also ought to be made that, but for that decided case, I'm talking about Frank Ejechum versus Attorney General.
Yes.
The 146, as he has just explained, or he has just stated, would have just stated, which is President, how do you call it, receives the petition, and then a committee is set up.
That is why, if Council just give me 1 minute, that is why I have maintained that the President has sort of taken a hasty decision in the suspension of the Chief Justice. Because you see, it is when matters go to the Supreme Court that we have certain interpretations, that we have certain guidelines that are provided for the application of the laws in the Constitution.
Right.
So if, for instance, we had not had the Ejechum case, the prima facie would not have been included in the removal process.
True.
So in a similar vein, I am faulting the President for taking a hasty decision because there is a case in court which borders on 146. It could so happen that the interpretation to be given by the Supreme Court on this particular instance of the writ by Asifo and another person could affect the processes.
That is true, but the counter argument there, and to be fair, it's John's turn, so I'd allow him to land. But the counter argument with that argument you're raising is also that the president has a constitutional duty to perform. I mean, you're not going to ask the president to wait until the Supreme Court is made before he continues or carries on with what is explicitly stated in the Constitution as to what his constitutional function should be.
I agree with you. The law is very much settled and clear that you cannot injunct the president from going ahead with his constitutional duty. Unless there's a court order. With this constitutional, even that, it will be very difficult for a court to injunct the president in going about his constitutional duties. But my point is that, knowing very well that the very process you are using under Article 146 is a subject for interpretation at the Supreme Court, which you know very well that the conclusions or any interpretation put on Article 146 by the Supreme Court would affect the process, the very process you are using to remove the CJ.
But best, when we do these decisions are made, they don't take an introspective effect. They take a progressive effect.
That is why it's even more reasonable to wait and see what will happen. Because you see...
Yeah, but that would be discretionary. Whether to wait or not to wait.
Yes, of course. I mean, I'm not...
That's the point I'm making. Just give me a minute.
Sure.
So when is your turn? I know John won't interfere, won't interrupt. Yes, John. And the good thing is you're good friends too. Your point is that 146, as per your understanding of how this law must operate, regardless of the Ejechum Attorney General case, is the president should have gone, strictly speaking, by 146 and forget about it
straight away. But I have the view that my learned friend knows about the rules of interpretation, where a statute conflicts with a superior court decision. Obedience is due to statute. This one is not just a statute. This one is the Constitution, the supreme law of the land. I'm saying the Constitution cannot take precedence over the constitutional provision.
That's fine. Please carry on.
That's my view.
That's fine.
And because there's no correct answer interpretation anyway. That's fine. But that's my view.
That's fine. Please carry on.
So I am of the view that the president has not in any way erred, but he's following the provisions as contained in the Constitution. And my learned friend said he faults the president for acting hastily. But the president is fortified by the Constitution. And it's not even the president alone. Mind you, if you look at the relevant provision, 146, 10A, 146, 10A, that clause 10.